guys, thanks for tuning in. For those of you that are already here, I see Peter, Jeff, Buzz, Lolly for Liberty, Birdie, Dr. Broden, Saddle Tramp. Hello, everybody that's here. Been hard at work. This was a rough week. For justice. It was a rough week for my client. It was a rough week for me as an attorney. But really, it's a rough week for the First Amendment here in the state of Texas, and specifically in Smith County. And I spoke to my client about this, and he really wants me to make this video. And so I want to do that because if you go and you read the media, unless you were there in the courtroom, you have no idea what was said in there, because the media did a great job of talking about everything that the prosecution said, and absolutely nothing of the defense evidence. And once you hear how the system ganged up on Mr. Phillips to secure a conviction, it should piss you off. It should make you upset. It should make you angry, and it should make you worried, because essentially right now, a man has been put in jail for speaking. That's right. A man is incarcerated for up to a year for speaking. That's what this all boils down to. But that's not what the jury got to hear. And that's what I'm going to kind of go through in this video. Let me just lay the groundwork here. Lance Phillips is a government accountability specialist. He's an auditor. He's a First Amendment advocate. He's a government, just whatever. I mean, he holds government accountable. And the machine in Smith County has been going after his entire family for one thing or another, because these are the people that stand up to the tyranny that's going on there. And there's a reason probably that there aren't that many people that are standing up there, because when they do, this is what happens. This is what happens in Smith County. You end up with these bogus charges. You end up with a county commissioner or a county commissioner's court that's out of control, that has absolutely no accountability. They're not required to follow the law, but then they expect you, the plebe, the common citizen, to follow the law. He was charged with well, let me just play what led up to what happened here, because everything I'm about to tell you is public. It's in the first of all, it's in a public record from the court records, but everything that led up to it is also is in the public domain here. No. All right, let me do this here real quick. There we go. So this is January 2nd, 2024. This is the County Commissioner's Court meeting for January 2nd, 2024 in Smith County. Here's the agenda. You got a call to order, declare a quorum present, blah, 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 and then public comments here. Members of the public who have previously filled out a participation form have an opportunity to address the Commissioner's Court on agenda items. The court is unable to deliberate on non-agenda items. Now, I'm going to come back to this because this is very important. Why is this even said? Why is this even said here? If you desire to request a matter on a future agenda, you may make the request to a member of the Commissioner's Court. Let me read that one more time. If you desire to request a matter on a future agenda, you may make the request to a member of the Commissioner's Court. Individual comments are limited to a maximum of 3 minutes. If you wish to address the court, obtain a blah, blah, blah. All right? Please be mindful of the Commissioner's Court rules of procedure, conduct, and decorum when making your comments and or attending public meetings. Now, one of the first items here is what's called the District Attorney's Office. And this agenda item here, number 2, it says, consider and take necessary action to authorize the district attorney to approve payment of accrued compensatory time and overtime from December 1st, 2023 through May 1st, 2024. This is the agenda item that Mr. Phillips is going to speak on. This is my client, Mr. Phillips. Again, I have permission to do this video from him. And he's about to speak to the county commissioner's court, and I want you to listen to what he says. Oh, I hope y'all can hear that. I can't even hear that. Hang on a second. I know I've got my screen sharing going on here. Let's see if that works.
Okay, right over here. We can reset it at 3. Okay, so y'all have, let's see, so don't want to disrupt the court today, and y'all know everything that I say falls under 551 Courtroom Code. If you think this, we can't hear you. Oh yeah, sure. If you think that something I'm saying is not related to number 2, then go ahead and put this subject on the agenda for subsequent meeting as per 551 for 042. Okay. Recently, current sitting Smith County judge has granted a motion to initiate a full investigation in the Smith County District Attorney's Office due to many intentional, false, and misleading statements coming from the DA's office. The DA, stop.
Now, if you notice, he's already getting interrupted 38 seconds into his 3 minutes. He hasn't even had a chance to go into anything. He's laying the predicate for his comments, but right now we're at 38 seconds into his 3 minutes, and the county judge is already cutting him off. Let me just back this up a little bit.
Attorney's office due to many intentional, false, and misleading statements coming from the DA. Stop. That's not 3 minutes. Stop. The DA's office this is about stop. This is all the time. Stop. They have a special group of humans who are bar card holders that are terrorizing our citizens and holding them hostage. I'm glad a judge has taken the first step to acknowledge this. It is my belief the DA is enforcing statute, supporting a policing for profit system, acting against the common law. By dumbass, they do not need to stop. Mr. Phillips, you're through. That's it. Now what? That's it. Thank you.
He was stopped at 1 minute and 2 seconds into his 3 minute speech.
I just want to remind everyone in this public comment section that you must speak on the agenda item.
Now, you probably didn't hear this, but in the background, one of the things that Mr. Phillips is doing is when he says, you must speak on the agenda item, Lance is saying, I was, Neil, you interrupted me. You interrupted me.
Mr. Phillips, no outburst from the crowd or you're going to leave.
And he says, no interrupted from the crowd or you're going to leave. And Mr. Phillips said, you're the one that interrupted my time.
Phillips.
Now, what you can't see here is after he says Mr. Phillips doesn't say a word. He just sits there. And what this is not going to show, although you might start seeing a few heads pop up, is Mr. Phillips is sitting back in the pew. I'm just going to say Lance. Lance is sitting back in the pew. He's sitting down. After he said Mr. Phillips, Lance stopped. But then 4 officers go and surround him. Now, you'll see a couple of them walking up here in a second. There's 1. There's 2. You can see heads. There's 3. And there's another one. Now, what happens is Mr. Phillips or Lance goes and he sits back in the pew. And as he's sitting down, you know, these officers, they all come and just surround him. They don't say anything. They just start surrounding him. So Lance scoots all the way across the pew down towards where the wall, like there's no walkway or anything. It's just, you know, there's a wall. It's the end of the pew is a wall. And when he scoots, because he doesn't want to be surrounded by a bunch of cops, for whatever reason. So he scoots all the way down. What do? They follow him all the way down and then just stand there. They just stand there surrounding him. And he's like, what are you doing? And then that's when they start taking him out. I don't know if you can hear that.
Take him out.
So he says, take him out, because Lance is asking these officers, what are you doing? Like, they're literally standing inches away from him, over him, standing literally over him. And him asking the cops, what are you doing? They're the ones that are intimidating him. They're the ones that are standing over him, lording to him, instigating him, trying to get him to respond. And when he does, take him out. That's what the corrupt county judge tells the officers to do. Now, by the way, he doesn't just say that on his own initiative. What you also don't see on this camera is the chief deputy motioning to the county judge, essentially asking him for this order to take him out. So this is very important because this guy here as you're looking, so it's essentially to the county attorney's right, our left. This is Lance Phillips' dad right here. And one of the things he says, and the prosecution kept lying to the jury, saying that Mr. Phillips was asking for a motion of contempt. That's not what he was doing. If you listen to this, and I would recommend you go to the Smith County Commissioner's Court, go to January 2nd, 2024, listen to this with headphones on because you might not be getting it here, the full audio. But the prosecution made it a point over and over and over again. Whose voice is that that's asking for a motion of contempt? Oh, that's Lance Phillips' dad. So his own father is asking for a motion of contempt. No, he's not. But what you're going to find later is that in the rules of decorum, that is one of the things that's supposed to be done. But if you listen to exactly what he says, and I'll play it one more time, and then I'll tell you exactly what he says. You'll see him lean over and talk to the judge.
Take him out.
Now, if you look here, the county even provides a transcript. We need to vote on a contempt charge if that's what you want to do, but he was interrupted. You can hear both of them talking over each other. We need to vote on a contempt charge if that's what you're going to do. And then the judge says it's not contempt. This wasn't his own father trying to get his son charged with contempt. This is his own father telling the county judge, we need to follow the rules. If we're going to do this, then we need to have a vote on contempt. But at this point, he's telling them, no, it's not contempt. Now, he's not telling them anything else, but the prosecution led the jury to believe, and I tried very hard to make it very clear that's not what he was saying, tried to get the jury to believe that his father is asking for a motion. His own dad wants his own son to be held in contempt. But that's not what he said here. And it's very clear. You can even see it right down here. We need to vote on a contempt charge if that's what, and then he starts talking over him. But you can hear his dad say, if that's what you're doing, or that's what you're going to do. But he says, it's not a contempt. So there's that. Now, at this point, the reason you hear him yelling is because they're dragging him from the pew. And he's trying to say, I haven't done anything. All right, I'm going to let this play. This right here, this man is the county sheriff chief deputy. This guy right here. This is the man that motioned to the county judge to get him to say, take him out. Because remember, they were standing over him, trying to get him to react. He reacts to them being in his personal space. And so this guy here motions over to this guy who tells him, take him out. And that's when they start dragging him out. Jacob is the county attorney, I believe. All right, so there you go. Jacob Putman. All right, there is that. Let me turn this off because it's just going to, let me stop that. There we go. So there's the video. There's the video of what happened. Now, I want to show you, and actually, I guess I'll bring up my screen again here. And I don't have my second screen plugged in right now because we're in the process of moving, so I don't want to. I've got everything all kind of packed up and everything. So I'm gonna share my screen again here. And just so you know, I'm not going to be able to see. All right. So again, go back here. The agenda item is right here. Consider and take necessary action to authorize the district attorney to approve the payment of accrued compensatory time and overtime from blah, 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 blah. Okay. Now, the prosecution was talking about these poor clerks, these poor, overworked, underpaid district attorney clerks who apparently that's who's trying to get compensatory time and overtime for it. Now, let me tell you something. Do you see anywhere in here where it talks about clerks? Do you see anything in here where it talks about anyone other than authorized the district attorney to approve compensatory time and overtime? No, this is the agenda item. There's no packet included. This is it. That's it. This is all that's provided to the public right here. This is it. This is the notice under Chapter 551 that's required under the law. That's it. This is it. No packets, nothing. And nowhere on here does it say there's other information that's a part of this agenda. So, if you'd like the other information, feel free to just call us and we'll give that to you. Right? No, nowhere. Nowhere does it allude to anywhere in here that there is additional information that the public should be aware of. The notice requirement under the government code. So all that anyone knows is this. They don't know who this compensatory time and overtime is for. It could be for the janitor. It could be for the guy that cuts the grass. It could be for the guy that does the jury instructions, the preliminary jury instructions. They don't know. Nobody knows. This is it right here. And what is Mr. As you saw in that video, what is he doing? He's laying the predicate for why he doesn't want the county commissioner's court to approve this money, because he thinks that the county or the district attorney's office is running a policing for profit scheme. Now, here's the other thing. It doesn't matter why Mr. Phillips disagrees with this legally. It doesn't matter. He can say, I don't think they deserve overtime because they wear green every Tuesday. That's his opinion. And if he is speaking on this agenda item and why he either approves of or disapproves of a payment of accrued compensatory time and overtime, it doesn't matter what his reasoning is. But County Judge Neil Franklin doesn't want to hear that. Because, by golly, these poor, innocent, underpaid, overworked clerks, they deserve this money. They work so hard. And here's this guy, Lance Phillips, who, by golly, he just doesn't want to get with the program. So we've got to do something about this. What do? They kick him out. Now, let's go to the government code. 551.007 of the government code is about public testimony, right? This section applies to a government body to describe blah, blah, blah. That's a county commissioner's court. A governmental body shall allow each member of the public who desires to address the body regarding an item on the agenda for an open meeting of the body to address the body regarding the item on the agenda before or during the body's consideration of the item. A governmental body may adopt reasonable rules regarding the public's right to address the body under this section, including rules that limit the total time that a member of the public may address the body on any given item, which is what they've done. And then it says down here, a governmental body may not, let me just highlight that word there, may not prohibit public criticism of the government body, including criticism of any act. Let me go back here one more time. This is to authorize compensatory time and overtime. The act that Mr. Phillips was trying to criticize was what he perceived to be the district attorney's policing for profit system, including criticism of any act, omission, policy, policing for profit, Now, whether or not there is a policing for profit policy doesn't matter. He believes there is. Procedure, program, or service. This subsection does not apply to public criticism that is otherwise prohibited by law. For example, threats, racism, or calls for violence, etc., etc. So in other words, unprotected speech, fighting words, things like that, okay? This is 551.007, public testimony. And there's a reason I'm bringing this up here. Let me go down to 551.042. 551.042. This is an inquiry made at a meeting. Section A. If a meeting of a government body, if at a meeting of a government body, a member of the public or of the governmental body inquires about a subject for which notice has not been given, as required by this subchapter, the notice provisions of this subchapter do not apply to a statement of factual information given in response to the inquiry, a recitation of existing policy in response to the inquiry, and then any deliberation of or decision about the subject of the inquiry shall be limited to a proposal to place the subject on the agenda for a subsequent meeting. Now, what does this entire section tell you? It tells you several things because this is the law. Number one, it tells you that a member of the public has a right under the law to make an inquiry at a public meeting about a subject for which notice has not been given. Now, keep in mind here, the argument that first of all, he was on the agenda, okay? So the fact that this doesn't even apply anyway, because Lance's words were about the agenda, okay? But let's just assume that we live in the fantasy land of authoritarianism and communism that Neil Franklin lives in, Judge Neil Franklin lives in, and that he was not on topic. Well, this provides that mechanism. It still says that you're allowed to. You're allowed to bring something up that's off topic. And there are only two things that the government body may do. They can state a fact, they can state a policy, or, and I guess there's three, but this is really about the deliberation. So they can either respond to a factual inquiry or to an inquiry about something that's not on the topic. Let's say that the topic is about pay there, right? And the person says, I would also like to talk about overtime pay for code enforcement. Which code enforcement is not part of the district attorney's office, right? So that would be off agenda for sure. But I also think that not only do I think the district attorney's office doesn't deserve compensatory and overtime pay, but I also think that code enforcement doesn't deserve compensatory and overtime pay. That's off agenda, right? Now, if he said something like, does this also include overtime pay and compensatory pay for code enforcement? Under the law, the county judge could have said, no, this is only related to the district attorney's office. Oh, okay. Well, then I would like, I think this should be put on the agenda meeting or on the agenda for next time because they're asking for compensatory pay and overtime pay for code enforcement. And then they can discuss or deliberate whether or not they're going to put it on the next agenda. Now, I want to go back before I go to the next law that I wanted to bring up and mention something here. If you look at the public comments, let me see if I can make this bigger somehow. Don't worry about it. It says right here, the court is unable to deliberate on non-agenda items. Doesn't say you can't talk about non-agenda items here. But then if you look at this, if you desire to request a matter on a future agenda, you may make the request to a member of the commissioner's court. It says right there, you don't have to be on the agenda. Right there in their own public comments section. Now, yes, by the way, I brought all this up. But it says right there, that they can do that. Now, let me go here to, this is a law that just went into effect last year. It was one of the few things that I remember working on when I got, since I got back from law school. This is section 51.002. It's called ordinance or rules inconsistent with state law. Now, look at this word right here. Ordinance or rules that are inconsistent with state law are prohibited. Notwithstanding 51.001, which is right up here, the government body of a municipality may adopt, enforce, or maintain an ordinance or rule only if the ordinance or rule is consistent with the laws of this state. In other words, when I read to you that the laws of this state allow for an inquiry made at a meeting that has nothing to do with the agenda, and how do you know that? Because it says a subject for which notice has not been given. In other words, it's not on the agenda. Okay, that's legalese for it's not on the agenda. So if I were to reread this, if at a meeting of a government body, a member of the public or government body inquires about a subject not on the agenda, then these things apply. Or don't apply, depending on how you read it. So state law says you're allowed to make an inquiry about an item off the agenda. And not only that, state law also says, under public testimony 551.007, that a government body cannot prohibit public criticism. There you go. So not only are they required to allow people to speak regarding an item on the agenda, which is what Lance was doing that day, but they are not allowed to prohibit them speaking about things that are not on the agenda. Why? Because it says right here in local government code 51.002 that you cannot have a rule that is inconsistent with the laws of this state. And a rule that says you will shut up if I think you're off topic or off agenda violates state law. And since it violates state law, it's prohibited. They can't do it. They can violate the law, but you can't. So I see the question here. So is Mr. Phillips and you going to appeal? We've already submitted my notice of appeal. I've got 10 points of error, and that's what I'm about to speak about. That's what I'm about to talk to you about. Not all 10 or anything, but I'm going to tell you how the trial went. So I just read you the law, right? Prior to the day of, and actually it was the week prior, a couple days prior to trial, prosecution filed what's called a motion in limine. Now, a motion in limine, for those of you who don't understand legalese, is where one party asks the court to prohibit the discussion of a particular topic or fact without first addressing that fact or issue outside the presence of the jury. In this case, the motion in limine that the prosecution asked for was literally no discussion about the First Amendment during trial, to the jury, during arguments, anything. That the First Amendment not be invoked here. Why? Because they say it's not a First Amendment case. Last I checked, the First Amendment was the right to seek redress. It was the right to speak. It was the right to talk to your government and complain about what your government is doing. That's the entire point of the First Amendment, was to seek redress. I got in there and I argued about the fact that, Your Honor, this is... Now, let me back up, actually. Let me back up, because I had a motion to dismiss this case based on First Amendment issues. And questions of law are usually determined by a judge. Questions of fact are determined by a jury. In this particular case, it just so happens that the First Amendment issue at stake here is both a question of law and a question of fact. And so I tried to get it dismissed on the question of law with the judge. I was told, no, this is a question of fact for the jury to determine. Okay. When we got there, they argued that, Your Honor, this is a question of law, not fact. And the judge said, you're right. This should have been brought up at pretrial. Your Honor, I did bring it up at pretrial. You told me it was a question of fact for a jury to determine. Now we're being told that it's a question of law for a jury to determine. Yes, that's being brought up in my appeal. The fact that the judge has determined that the First Amendment is neither a question of law or a question of fact. And here's what I mean by question of fact. For example, some speech is not protected. Fighting words, the courts have said fighting words are not protected, threats, things like that. The stupid, worn out argument about you can't yell fire in a crowded movie theater. Well, yeah, you can. If there's a fire, you can. I would hope that people would yell fire in a crowded theater if there's a fire. But that's the example that's mostly given. But let's just say it's for example, calling a police officer a motherfucker. Well, a jury, first of all, it's protected speech. But let's just say that it's a fact issue. Okay, well, did he say it to say it? Or were they fighting words? And there's very specific ways in how that's determined, is how fighting words are determined. Believe it or not, there are some sort of elements to determining that. But that's for the jury to decide. Just like in this case, whether or not he was off topic should have been a fact issue for the jury to decide. But we were prevented from even mentioning the First Amendment in this case. That's the first issue. The second issue is I got when we got the county judge up there and I started my cross-examination, one of the questions that I asked him was about his training on the Open Meetings Act. Oh, objection, relevance, sustained. So I asked to approach the bench. I said, Your Honor, the Open Meetings Act is incredibly important in this case, because if the county judge violated the law in doing what he's doing this entire time, then the order for him shutting up Mr. Phillips and getting him removed is illegal and unconstitutional. The Open Meetings Act is very relevant to this particular case because the county judge is violating the Open Meetings Act and other laws, by the way, in this very case. Sustained. So I wasn't allowed to talk about the law that the judge was supposed to go by, and whether or not he was aware of the law. And I wasn't allowed to talk about the First Amendment. Those are the two main defenses to speech that we had in this case. And the judge didn't let us use any of them. Didn't let the jury hear the fact that the county judge literally broke the law that day on January 2nd, 2024. Literally broke the law. But I wasn't allowed to tell them that them cutting off his speech for allegedly being off topic or off agenda was against the law. I wasn't allowed to attack the fact that their rules of decorum violated state law. Now, I'm going to bring something else up here real quick because see if I can find these real quick. Here it is. All right. Let me share this. Oh, there we go. All right. Where'd it go? Here it is. All right. These are the Smith County Commissioner's Court rules of decorum. These were presented and brought into evidence. Of course, I wasn't allowed to discuss whether or not these violated the First Amendment, but let me remind you of something here. Rules. This word, rules. Let me show you this. Rules. Section 51.002 of the government code, local government code, applies to rules inconsistent with state law. Okay? These are the county commissioners' rules of procedure, conduct, decorum at meetings. Let's go down here. Section 4. The business of Smith County is conducted by and between the members of Smith County Commissioners Court and those members of the county staff, elected officials, department heads, consultants, experts, and or members of the public requested to be public or present and participate. While the public is invited to attend all open meetings of the Commissioners Court, participation is limited to that of an observer unless a member of the public requested to address the Commissioners Court on an issue or issues, or unless a public participation form has been completed and submitted to the Commissioners Court staff prior to court. Public comment is limited to comments about an item or items on the Commissioners Court agenda for that particular meeting. The individual or individuals may comment either before or during the body's consideration of that item. Then it says down here, you'll be limited to 3 minutes to make your comments. Maximum discussion on any agenda item for members of the public. If there's a lot of people, it's 30 minutes. They can suspend that allocation if they wanted to. And then this right here. While it is the intention of the court to provide open access to the citizens of Smith County, members are advised that the court is a constitutional court with both judicial and legislative powers under blah, 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 blah. Now, this is also where Judge Franklin seems to be somewhat confused and doesn't quite understand exactly what his limitations are. It is true that under Article 5, Section 1 and Section 18 of the Constitution, the Texas Constitution, that a county commissioner's court is both a constitutional court, or is a constitutional court with both judicial and legislative powers. And there are times that it exercises judicial powers, and there are times that it exercises legislative powers. But it cannot do both at the same time. It is doing, whenever it acts, it is doing one of these things. When the county commissioner's court holds a county commissioner's court meeting under the Open Meetings Act, it is exercising at that point its legislative powers to create policy, et cetera, et cetera. It's not exercising its judicial powers during a county commissioner's court meeting. Even though it has the ability to hold someone in contempt, an open meeting by a county commissioner's court to discuss items on an agenda is the county exercising its legislative powers, not its very, very limited judicial powers. Nowhere in the Constitution, nowhere in the state law does this agenda item stuff that they're doing at these weekly county commissioners court meetings have anything to do with their judicial role. But let's keep going. Any member of the public shall conduct themselves with proper respect. There's the first somewhat issue here. Now, obviously, when you are in court, there's rules of respect and things like that. But when it comes to a legislative body, the fact that there is a mandate that you respect government officials is on its face unconstitutional. People don't have to respect government. Now, they have to respect, for example, the legitimacy of a court. They have to respect when people are acting within their constitutional authority. They have to respect that authority. They have to respect those decisions as long as they're made according to law, but they don't have to respect people. No one in government has to be respected. And for anyone to say that you will respect my authority, I'm sorry, that violates the First Amendment. Go down a little bit further here. Here it is, right here. The court will not allow a member or members of the public to insult the honesty and or integrity of the court as a body, or any member or members of the court individually and collectively. Once again, a violation of the First Amendment. and a violation of state law, because state law allows you and prohibits them from limiting criticism of an individual, of the court as a body, or as a member, or as members. If somebody wants to get up there and says, you know what, you're a dishonest person who lacks integrity, they can do that. That's their opinion. But yet this rule of decorum directly violates state law. And you know what? I wasn't allowed to talk about the First Amendment. I wasn't allowed to talk about the fact that this rule right here, F, 4F, violate, whoops, oh, what did I just do? Go away. Violates state law and the First Amendment. Wasn't allowed to talk about that. It also says no profane, insulting language. Again, protected. Threatening language, okay, that's not protected. That can stay in there. Threatening language is not protected if you're making threats. Obviously, there are racial, ethnic, or gender slurs, whatever a gender slur is, or epithets will not be tolerated, but that can also stay in there. And then, ironically enough, after saying how they're going to prohibit and how you are restricted and criticized in the court, these rules do not prohibit public criticism of the commissioner's court. I mean, let's go back here. You will not insult the honesty or integrity of the court. You will not use profane or insulting language. But don't worry, that doesn't mean you can't criticize us. You can criticize us. You just can't use profane language. You can't use insulting language. You can't call into question our honesty. And you can't call into question our integrity. Everything which is protected speech here. And then finally, this down here. A violation of these rules. Now, one of the things I also want to notice, and I brought this up in court as well. Nowhere in here does it say that when addressing the court, you must do so from a particular place. It doesn't say you have to go to the podium. It doesn't say you have to use a microphone. It doesn't say anything. Nowhere. And so there's no rule in here that says that Lance could not speak from the gallery. There's no rule. Now, what I want to do, I'm getting ready to go back to the video one more time, and I want everybody to kind of get a stopwatch out, whether it's on your phone or, whether you've actually got a stopwatch on you or you use your computer. But I'm going to give you about a minute or two to just, for those of you watching right now, go grab your phones and open up the stopwatch feature. Because I'm going to uninterruptedly start Lance's video here in just a minute. Okay, so that's just your sort of heads up, because I want you to do something with your stopwatches. Stand by. But remember when I mentioned how the prosecution said that Lance's dad was calling for contempt? No, he was asking for, if there's a violation of the rules, here's what they can do. They can cancel the speaker's remaining time, but he didn't violate any rules. He was speaking on the agenda, and he was allowed to speak on the agenda. It even says up here that they can... it's up here. Trust me. I just read it to you guys. Agenda items. Here it is. The individual or individuals may comment... that's not it. Public comment is limited to the individual or individuals. The Commissioner's Court that is properly posted on the agenda. Maximum discussion. I know it was down here somewhere. Maybe it was down here. Here it is. Anyway, it says that you can't. Oh, no, I know where it was. It was on there. That's right. It was on the agenda itself. But violation of these rules can cancel a time. Again, I wasn't allowed to mention the fact that when his time was canceled, he didn't violate the rules. As a matter of fact, the only person that violated the rules was Judge Franklin. You can get removed from the Commissioner's Court, a contempt citation. Now, that's what Lance's dad thought that it was happening, was that he was going to do a contempt citation. More on that to follow, by the way. Or any other such civil or criminal sanctions as may be authorized under the statutes and code, which is what they did. They charged him with hindering a government proceeding by disorderly conduct. All right, now, Let me close that. Let me go back to the video. Everybody hopefully has your stopwatches out, right? You have your stopwatches out. Now I want to show you something. Let me start this real quick. Don't do anything yet. Don't do anything yet.
Okay, right over.
Get ready.
We can reset it at 3.
All right. We can reset it at 3. The stop, as soon as I hit play, I want all of you to start your stopwatches. Okay? As soon as I hit play, start your stopwatch. 3, 2, 1.
Don't want to disrupt the court today, and y'all know everything that I say falls under 551 government code. If you think it's we can hear you. Oh yeah, sure. If you think that something I'm saying is not related to number 2, then go ahead and put this subject on the agenda for subsequent meeting as per 551 for 042. Okay. Recently, current sitting Smith County judge has granted a motion to initiate a full investigation into Smith County District Attorney's Office due to many intentional, false, and misleading statements coming from the DA's office. The DA, stop. That's my 3 minutes. Stop. The DA's office is. This is about stop. That's not all the time. Stop. They have a special group of humans who are bar card holders that are terrorizing our citizens and holding them hostage. I'm glad a judge has taken the first step to acknowledge this. It is my belief the DA is enforcing statute, supporting a policing for profit.
Don't stop your clock until I tell you.
By us, they do not need to stop. Mr. Phillips, you're through. That's it. No, I'm not. That's it. Thank you.
Don't stop your clocks yet. Keep them going.
I just want to remind everyone in this public comment section that you must speak on the agenda item. Mr. Phillips, no outburst from the crowd or you're going to leave. Mr. Phillips. Take him out. We need to vote. It's not a contempt.
Now stop your clocks. What do you notice about that? You should have approximately 2 minutes and 37 seconds on your stopwatches. Anybody get something different? Approximately, give or take a couple seconds. I got the comments there. I counted, and again, I had the other video that shows what's going on in the audience as well. But I'm only using what's public right now, what's out there. I'm not going to use what was admitted in court yet because we are appealing this case, and I don't want to use the exhibits and everything until the case is finalized. So this is all right there, public comment. So everyone should have had about 2 minutes and 37 seconds. And if you remember, once again, it said right there, you've got 3 minutes of public comments. And the only time they can cut off, the only time he can cut off your time according to their own rules is if they violate the rules. There was no rule being violated, and any rule that they claim was being violated state law itself, which means the rule that he said was violated was unlawful and couldn't be used. This idea of hindering a government proceeding, hindering is it's a pretty obvious word. You know, if I'm trying to go through a door and somebody gets in my way, they're hindering me from forward movement through that door. If the county commissioners are speaking on something themselves and I'm screaming and yelling and preventing them from being able to carry on with the meeting, that is hindering the meeting. If I'm trying to fill up my car with gas and someone keeps going and flipping up the thing so I can't fill up my car, they're hindering my ability to fill up the car. Hindering, to prevent someone from doing something or to delay someone from doing something. As you saw in this video, from the time that the clock started till the time that he was dragged out of the building was approximately 2 minutes and 37 seconds. You could argue, and I did, first of all, hindering never existed because it was his 3 minutes. He didn't unnecessarily delay anything. As a matter of fact, you could argue, and I did, that he saved the county commissioner's court 23 seconds. They were able to get on with their agenda 23 seconds faster than if Mr. Phillips had simply been able to speak for his 3 minutes. As this says, as I want to highlight this because this is very important. This doesn't have a chilling effect on the First Amendment. This kills the First Amendment in Smith County. If you've got a judge that thinks he can determine whether or not what you're speaking on an agenda item, and by the way, this happens here in Killeen, Texas too. And yes, we're suing over this issue. As a matter of fact, I've got the state's response, or the city's response to my lawsuit, where they talk about this very issue about staying on agenda, and you're going to be surprised. Now, this is all public. If you go to, by the way, this is in the Western District of Texas, Waco. If you've got a Pacer account, just go and look up 24-CV-342 and look at the defendant's Rule 12b6 motion. They will also tell you that they can cut people off for quote unquote not being on agenda. And it's their opinion. It's their opinion. This doesn't have a chilling effect on the First Amendment. It neuters the First Amendment. It destroys the First Amendment. And by the way, it's because of these actions in Smith County. Here's where the chilling effect does come in, and where and I agree with Boda Bob, of course, right here. I agree. There's also a chilling effect on this. How do I know? Because there are people who have come forward saying they don't even go to city council meetings anymore because they know they're just going to be shut down. They're not going to be able to speak. And some elected king of a commissioner's court who believes that he has the authority and the power to dictate how people discuss agenda items and what their opinions will be and how they will expose those opinions. Why even go anymore? Now you've got citizens who refuse to take part in the democratic process, the Republican process, because they know they're just going to be shut down. That's the chilling effect. The chilling effect is now you have fewer people willing to go to these meetings and see what's going on because they know they're just going to be ignored. It's absolutely, and that's prior restraint is what that's called. That's prior restraint. So this is very sick, what's going on here. Now, I want to tell you that this is what, if I want to go and speak on an agenda item, and let's say that agenda item is about whether or not we should allow a comic book shop, whether we should grant a license for a comic book shop to open up in, on this little strip of land or whatever, right? This is just out there. So the agenda item is to discuss granting a business license to local comic book shop on X road, ABC road. Well, if I go up there and I say, when I was a young kid, I didn't really get to go out much, and I was stuck in my house all the time, and I was bored out of my mind. I lived out in the middle of nowhere, and I just, it was really sad. It was a very sad existence. I worked on a farm, and it was just all we did was we woke up early and we went home late, because out all day long I'm sitting there. I'm either cutting hay or rolling hay or baling hay or cutting wheat, and harvesting wheat or corn or whatever, and not milking. We don't milk cows, but feeding the cattle, watering the cattle, making sure the cattle aren't sick, inoculating them. So, and then, you know, we go home and there'd just be nothing to do. We're out here in the middle of nowhere. It's a farm, you know, and I go on for 2 minutes and 50 seconds about farming. And why would I do that? Because one day I'm at a gas station. This is how I would end it. One day I'm at a gas station. I see the Superman comic book, and I pick up the Superman comic book, and it changes my life. I read more. I understand what's kind of going on in the world more. You know, I'm able to take my mind off these other things because, oh my gosh, comic books are now, you know, I don't have to think about reality. I can just find myself in a comic book. And so for that reason, you need to approve this, you know, approve this license. Now, you see what I did there? I talked for 2.5 minutes, almost 3 minutes, about something that you would think is off the agenda. What does farming have to do with comic books? What does rolling hay have to do with comic books, or harvesting corn have to do with comic books? Well, you know, it took me 2.5 minutes to tell you why it's important that we allow this comic book store to open up in our town, because we don't have a bookstore in our town. We don't have comic books in our town. Now we will. But they didn't give Lance Phillips that opportunity to discuss why he's opposed to granting compensatory or overtime pay for whomever. He can say that and keep in mind, every single one of these individuals that was looking for compensatory and overtime pay works for the district attorney's office. And if the district attorney's office, it is believed that they are engaged in policing for profit, then you have a right to say that no one should get compensatory time for any reason. You could argue they don't even deserve the money they already got. They're already overpaid. But Lance Phillips didn't get that option. That's why we lost the case. We didn't lose the case because the facts were on the state side. We didn't lose the case because my client did something wrong. As a matter of fact, every noise that he made was in response to something that the state did to violate his rights. But the jury wasn't able to hear that. They weren't able to hear that the county commissioner's court and county judge specifically violated state law. They weren't allowed to hear specifically that they can't dictate his First Amendment right to speak on an agenda item in any way that he sees fit. That's why we lost the case. That's why there's a chilling effect on the First Amendment. And that's why I'm going to continue to fight these issues. I don't care where it is in this state. So, yeah, Ozzy, just go away. You're here. It means you're about to get educated for the first time in your life. You guys take care. Be safe. Be free. And pray for Lance and his family. I should be getting him out of jail hopefully this week. I already filed the motion for a bond and for a stay on his punishment pending the appeal. I've already submitted the notice of appeal. Once I get the transcripts, I can file the actual appeal. It's going to be a good one. And I look forward to Lance being able to speak to you himself. But I wanted everyone to understand what's going on in the state of Texas. It's not just in Smith County. This is not only happening in one county in Texas. It's not just happening in Texas. Go look at my Facebook page for my law firm. I just posted a video out of Arizona for the exact same thing. We need to stand up, people. We need to stand up for our rights. We need to stand up for freedom. Take care. Be safe. Be free. I'll see you next time.